Hi and welcome to my estate planning update for 2009. My name's Ward Wilsey and I'm an estate planning attorney in San Diego, California. If you have any questions concerning today's presentation, please call me at 858-764-2672 or send me an email to the email address you see on your screen. As a disclaimer, this is not tax advice per Circular 230 issued by the U.S. Treasury Department. No one may rely on this information to avoid penalties imposed by the Internal Revenue Service or any other organization. No one may use this presentation to market any sort of tax-related strategy. This does not constitute legal advice, and listening to this presentation does not constitute an attorney-client relation. I want to start by talking about the estate tax exemption. In 2009, individuals are able to exempt up to $3.5 million of their estate from estate taxes. This would be $7 million for spouses if the estate is structured correctly. The estate tax rate is 45%. So for example, if a single person dies with a $5.5 million estate, you'll subtract the $3.5 million exemption to leave a $2 million taxable estate. Multiply that by a 45% estate tax rate, and you've got a $900,000 estate tax. With regards to the future of the estate tax, I have no clue what the estate tax exemption will be going forward. Now, President Obama's campaign pledge was for a $3.5 million exemption, but Congress actually makes the law, and congressional heads have been hinting at a lower exemption. My guess, and this is just for the sake of seeing if I was right, is a $2 million exemption adjusted for inflation with a 45% estate tax rate. But what's clear is certainly there's no effort to repeal the estate tax, so planning for affluent clients is a must. In 2009, a donor may gift up to $13,000 to as many individuals as they would like. So for example, if a husband and wife have 3 kids, they can gift up to $78,000 to those children. Any gift above this amount, or a gift that does not qualify for the annual exclusion, is subject to a gift tax, unless the donor can apply their $1 million lifetime gift tax exemption. We'll see how this works in a minute. First, I want to go over what types of gifts do not qualify for the annual exclusion. This includes gifts over the annual exclusion. So for instance, if you have gifted someone $15,000 in 2009, $2,000 will not be subject to the annual exclusion. Also included are gifts that are not of a present interest. So for example, if you give someone a gift that does not take place until 5 years from now, that's not a gift that qualifies for the annual exclusion. And finally, gifts to trust without the right to withdraw. If you make a gift to a trust, in order to qualify for the annual exclusion, the beneficiary must have a right under the trust document to withdraw the gift for a certain period of time. And this should be evidenced by what's called a crummy notice, wherein the beneficiary acknowledges that they had this right and they knew they had the right. With regards to the lifetime gift tax exclusion, the gift tax exclusion is currently $1 million per person cumulative. This means not per donee. So for example, if John gives $100,000 to each of his 4 children, he has made a gift of $400,000 unless he can apply an annual exclusion. This would reduce his lifetime gift tax exemption from $1 million to $600,000. Gifts in excess of the $1 million exclusion are subject to a 45% gift tax, unless an annual exclusion can be applied. I like to say there's a perfect storm of estate planning opportunities right now based on 3 factors. Number 1 is a reduction in asset values that will likely rebound within the next few years. Number 2 is low interest rates allowed by the IRS for estate planning purposes. And number 3 are estate planning techniques that allow you to give away assets yet retain the use if absolutely necessary, subject to certain restrictions. Strategies that I like to use are irrevocable gifting trusts, such as irrevocable life insurance trusts, in which clients' life insurance, which either exists or is purchased in the future, is removed from their estate, meaning it's not subject to estate tax on the death benefit. I also like family gifting trusts, where clients make gifts into irrevocable trusts, yet retain use of those assets if absolutely necessary. Family limited partnerships are a great strategy if done properly. They allow for centralized management of assets, they allow for asset protection, which is often most important, and they also allow for discounted values, meaning reductions in values for estate tax and gift tax purposes. One of the most important tools in my estate planning arsenal are freeze transactions, such as qualified personal residence trusts, or QPERTs, sales to grantor trusts, and grantor retained annuity trusts, or GRATs. While an in-depth discussion of freeze transactions is beyond the scope of this presentation, I want to give you a general overview of how this works. The idea is that the difference between the future growth of an asset and the current interest rate passes outside of the estate. So, if you sell an asset growing at 8% for a promissory note bearing interest at 2.5%, that additional 5.5% compounds outside of the estate. These transactions can be structured with no capital gains tax. This allows clients over the course of their lifetime to move a great deal of their assets outside of their estate. I want to give a brief update of qualified retirement plans. The Worker, Retiree, and Employer Recovery Act of 2008 suspends required distributions from defined contribution plans and IRAs for the year 2009, and this applies to qualified retirement plan owners as well as beneficiaries. And this is true even for beneficiaries who are subject to the dreaded 5-year rule, in which distributions must be made within 5 years of the original qualified retirement plan owner's death. So if you've inherited an IRA or 401k recently, you may want to take advantage of this for yourself. Well, thank you very much for listening to my presentation, and if you have any questions on this or estate planning, trust administration, or probate in general, please give me a call at 858-764-2672 or send an email to the email address on this screen. Thanks again.